Welcome back to all our subscribers and listeners. We're so happy to have you guys join us for another episode of Legal Tea and Things. And we're so excited about the episode today. So before we kick off, for any new subscribers, we just want to tell you a little bit about us. So I am Jan, and
I'm Dominique.
And we are both 1Ls at Stetson Law, and we're here to bring you another episode.
Yeah, contracts of passion gone wrong.
Yep, and we're both pretty excited about this episode, and we think everyone's going to enjoy it. So let's get started.
Yeah, let's kick it off. Go ahead, Jen.
All right, so today we're looking at contract law, and this is not just any old contract, but or actually maybe not a contract of passion, and it's gone wrong. As always, we're going to follow the normal outline that we do to bring you your weekly dose of legal tea and things. So we'll start with the facts, we'll discuss the issues at hand, and then we'll give you each side's argument. We'll take a short break, and then we'll come back and let you know where we fall out, and then let you know how the court decided. So let's go ahead and get started. So what case are we going over today, Dominique?
We're working with the king of petty today. in the infamous Tompkins versus Jackson, the 50 Cent case. Obviously a pretty interesting one of a contract gone wrong. I like how you said it may not be a contract. Okay. I caught that. It's contracts of passion gone wrong. So keep that in mind. So we're working with Tompkins versus Jackson in the issue of Miss Shaniqua Jackson saying that Curtis Jackson, aka 50 Cent, promised to take care of her for her lifetime and to sign over a house to her.
All right, yeah. So you're getting into the issues a little bit. Let's get to these facts before we jump to the issues.
Go ahead, Miss May not be a contract.
So I'll kick us off. So as she said, Curtis Jackson, I think a lot of people know him as 50 Cent. He was a defendant in this case, and Shaniqua Tompkins was a plaintiff. So they dated, and I want to say they started dating about 1996.
Yeah, it was an 11.5-year relationship.
All right, so 11.5-year relationship. They weren't married, but they did live together sporadically. And according to Tompkins, she said that there were some oral promises that Jackson had made. I know earlier Dominique alluded to one being that she would take care, that 50 Cent would take care of her for the rest of her life. Who knows what that means?
I like how you're asserting your argument in the facts. Wait till we get to the arguments.
Okay. All right, that's fair.
Once he made it big in the industry, he would take care of her for the rest of her life. Yes.
Right, and she was saying, she met him when he was a street dealer. She took care of him after he was shot 9 times. She cleaned for him, cooked for him.
Took care of their son.
And just that he had made some promises to her, and she was seeking to get those promises enforced. Any other facts you think you want to talk about before we get started?
I think that'll at least do for the overview of it. I think the important thing also to note is the fact that they lived together. I liked how you said sporadically. I'm going to give that to you because the case said it. But prior to some of these issues, he did, in fact, live with her in multiple locations over 11.5 years.
Okay, so I do want to elaborate on that because
yes,
he didn't quote unquote make it big maybe until somewhere in the 2000s.
Yeah, like early 2000s, 2003 or something like that. Yeah,
so when we say live together, maybe that was like he was sleeping on, they were living with her mother or his grandmother.
Or her grandmother,
sleeping on couches.
Yes.
But we don't know if during that time there was sort of monogamy in that relationship where, he wasn't sleeping on somebody else's couch.
Okay, you know what? Marriage is not equal monogamy or even relationships.
I'm just saying, if we're making
I think, claims, my biggest thing is like where you keep your underwear, aka your drawers, that's where your house is. And he kept it with Shaniqua for 11.5 years. That's all I'm trying to say. But yes, they lived in various locations, and I think they were homeless at one point as well. Right. Something that she alluded to a lot in her petition. So yeah, they had a very tumultuous relationship There's some allegations of assault that was in the original petition as well.
Yeah.
And there's a lot of things about business agreements. They're going to write a book together, apparently, that they never.
And actually, I don't know if that was together. I think it was through his publishing company.
I think
and that
so
was a
too.
means for her to establish herself and try to have a career.
Again, asserting your argument in the facts.
No,
he made an oral promise to write the book. Now, by the way, he actually did go on to write his life story. It's called Get Rich or Die Trying, which she didn't get anything from. But I'm going to leave that at that, even though apparently there was an oral agreement to write this book together or whatever. So
I think something else, too, that I forgot to mention was they do have a son. So
yes, who he hates, which is interesting. So...
Well, you are jumping ahead to present day.
I don't know if he hated this little boy when he was born, but I know he hates him now. So, but yes, they have a son, Marquise. 50 Cent's first child looks just like him.
Yes, well, she did. So she had a daughter before 50 Cent, and I want to say I don't think he adopted her or anything, but I think he did help take care of her.
Yes, I believe so as well.
So there were two
until
children.
this suit came up when he was just like, you and your child. That would have hurt my feelings.
Yes.
Look, you're not my daddy no more? Like, what's that? But yes, she did live with him, and he did say, it was really funny because it was like specific language in the court documents that was just like, Miss Tompkins and her daughter were living with my son. Yeah. So yes, this is a very, very this is a very interesting case, a very interesting petition. It's very interesting how it was written too. So yeah, there were a couple of other things. Like I said, it was a joint venture agreement, the assault and battery, fraud, which was interesting. We'll get into that argument later, but yes. So you want to talk about what is this
a good segue for us to jump to the issues?
Let's jump to the issues. Yeah, let's get into it.
This has been all over the news, and so
yes, it was.
I think we've laid enough sort of the framework, so we'll jump into the issues now.
Yes.
I will kick us off there. So the first issue at hand was around do express or implied agreements amount to a contract? So the plaintiff, Shaniqua, was arguing that there were several express agreements. Mm-hmm. So one was related to a home, that he was supposed to put her name on the title of something called the Dix Homes Property. Another one that Dominique previously mentioned was writing a book together.
Right. Mm-hmm.
And I think the third one was to take care of the plaintiff for life. So 50 Cent essentially said, is alleged to have said, when I make it big, I will take care of you for life.
Yeah, for sure. And another issue is, are contracts for payments in exchange for personal services between unmarried people living together void against public policy? So
that's another good one, right?
So
can unmarried cohabitants lawfully contract concerning their financial or other matters relevant to their relationship? And I know sometimes we see the term like palimony, since they weren't married. You don't have like that alimony.
Common law marriage.
Right. And we'll definitely get into that. Any other issues, you think?
I think that covers...
Okay. There's some sub-issues within there, but I think
there are a lot of and we'll kind of get into some of those sub-issues when we talk about our legal analysis. Yeah. Do you want to talk about the arguments on...
Yeah, why don't you start us off?
I'll start us out with the arguments. I don't mind talking about the arguments. So one of the biggest things that Miss Tompkins argued was unjust enrichment, right? So unjust enrichment, this theory of, hey, I just want to get what I was owed, primarily because Mr. Jackson was being taken care of for 11 and a half years, and he didn't provide a lot financially, but I performed this duty, and I performed it on this, on the promise of, when you get big, you'll take care of me, and other things. The other one is quantum merit, which is Latin for as much as he deserved, which is the value of benefits provided without a contract. is when a plaintiff brings a claim for restitution and that value provides the measure of recovery. So again, that's kind of like a 2 and 2 pillar there, unjust enrichment and quantum merit. I performed, pay me. It's not unjust. I'm not getting something that I don't already deserve. And quantum merit adds this factor of I don't have a contract, which kind of leads to, and I won't get into that third topic yet, but because I think that's more of a defense that I would make.
What's that third topic? Just for
promissory estoppel,
okay.
Which ties this all together. That's what I would have done. But we'll get into why I don't agree with this unjust enrichment thing. The other thing is, I think more on your side, but there's a breach of contract there, which is, hey, you've made this promise. It's a contract, even though it was orally agreed, and now you've breached it. So those are the things that she claimed and her lawyers claimed in this petition.
Okay. And yeah, so just sort of summarizing that a little bit. So essentially, Shanique was saying, hey, there was this promise, this agreement. Mm-hmm. It should be enforced. That's why I'm taking this to the courts. And hey, these are the different ways I'm going to seek remedies. Or
and you've unjustly
you've breached this contract, and you need to pay up.
And you need to pay up because you've unjustly been enriched
for
me cleaning and cooking and taking care of your child, and taking care of you. I mean, like you said, he was shot 9 times, and he survived, and she took care of him, and all this other stuff. So she's saying he was unjust.
Like he wouldn't have survived without her, huh?
That's what I'm gonna say later on in this podcast.
All right, let me go into the defendant's arguments. So 50 Cent, and I guess I should call him. I don't even remember his first name.
It's Curtis.
Curtis.
You can call him Curtis. I'm gonna call him Curtis every time I get mad, so you can call him Curtis.
Yes. So
you can't even trust somebody with that type of name, Curtis. It's like trusting someone named Sylvester, like R. Kelly. His middle name's Sylvester. See.
All right. So Curtis said he maintained. So I mentioned the whole idea. Hey, was there a promise or an agreement? Is there a contract? And Curtis maintains that for the breach of contract claim, which he says is actually a claim for palimony. That's a term, I want to say that was coined in California courts, but
I believe so.
He said, hey, no oral contract ever existed. Earlier we talked about the expressed agreement, I think. Expressed implied agreement. So he's saying, hey, that doesn't exist. He's saying that purported contract that you're saying exists is actually barred by the statute of frauds and statute of frauds and the statute of limitations. We'll talk about that when we go over our takes. And then he also said, it lacked the requisite specificity and then mutual assent and any definition. So he's saying, hey, there's no contract ever had. And that's sort of, I'd say, the basis of his argument. He goes into more explaining that, and we'll talk about that when we give our take. But he's essentially saying, hey, this shouldn't even go before court. And he actually sought summary judgment. And so that's sort of what we'll be looking at today.
Yeah.
I think that gives a good summary of the facts, the issues, and the arguments. So let's take
a quick break. Yeah.
And we'll get on to the fun stuff.
Yes.
All right. This podcast is brought to you by Squarespace. Squarespace is a free website builder that allows you to share what you're passionate about with the world. Millions of people and businesses are using Squarespace, like Legal Tea and Things, and you can too. Join today using our promo code LegalT and see why Squarespace is trusted by the world's best brands like Target and Lyft. Again, our promo code is LegalT. Head on over to Squarespace and let them know the Legal Tea and Things team sent you. All right, welcome back. We're on the second half of our show, and we're going to continue with our outline. So we're going to go into sort of the juicy stuff. We're going to give our legal tea take, and then we'll let you know how the court decided.
Yes.
So Dominique's going to be sort of taking the side of the plaintiff here, and I will be supporting Mr. Jackson.
Oh, now he's Mr. Jackson.
Yeah.
He's going to be Curtis in my argument, by the way. But yes, I'm going to represent Ms. Tompkins in this issue. So.
All right. So we're going to go ahead and get started. And I think just to sort of level set. So I know earlier we talked about the issues, and the first one was, hey, is there an express agreement? And well, there is an express agreement. So the question is, does this amount to a contract, right? And so I think this is a good point just to sort of review sort of what is an agreement.
Yeah, and what is a contract?
Yeah, what is a contract?
Yeah.
So I think when contracts first kicked off, it's like, hey, what is a promise, and then what is an agreement?
Yes.
And so a promise is essentially a manifestation of intention to act or refrain from acting in a specified way, so made as to justify a promisee and understanding that a commitment has been made. And I know that's just like
a lot of legalese.
Yeah. But essentially, like, you have a promisor and a promisee, and it's more unilateral in one dimension, whereas agreement is more bilateral, right? So you have two parties and they exchange their promises, and each one receives something back in return. And I'd say here we have essentially an express agreement. That is the claim.
Yeah, it's a bargain.
Yeah, and you said sort of another thing is like, well, how do you know when we have agreements? Because I think something you've learned from other episodes that we've done is that, hey, like, not every contract should be enforced.
Yes.
We wouldn't even need the legal system if we could just enforce everything,
every single promise that.
Yeah, so like with agreements, how do you decide what to enforce? And there's different tests that can be used, and one that people often hear is like the Embry test, and that's essentially looking for mutual assent. And I know previously I gave Mr. Jackson's argument, and he said, hey, there wasn't even mutual assent.
And mutual assent is a offer and an acceptance, so they kind of marry each other and create this mutual assent.
Right, and that goes again to that sort of bilateral piece of things.
Yeah, the meeting of the minds.
Hey, what would a reasonable person do if you're looking at more of like a mixed approach? But,
I think a reasonable person would promise that if you take care of me, since I got shot 9 times, I'll take care of you when my rap career takes off.
Okay. I hear you.
Mm-hmm.
We'll come back to that. So we're going to look, hey, is there even an agreement that can amount to a contract? And then sort of once you can establish, hey, there is a contract, then we can say, can this contract be enforced? And it looks like Miss Tompkins is saying, hey, I had a contract.
Yeah.
He breached his contract, and you guys need to enforce
it. Yeah, exactly.
And this is how I think that you should make me whole.
Yes, and he is saying there was no contract. This is just something said in the heat of passion, and we're just lovers that have gone awry.
All right.
Yeah.
Okay. So the first thing is, can an express agreement amount to a contract? And so, the burden of proof actually lies with the plaintiff.
On me. Yeah. Exactly.
But
so I don't mind taking it. It's fine. Can an express agreement amount to a contract? The answer clearly is yes. We have case law that proves that can actually happen. So we look at some relevant case law where that has happened is Kozlowski versus Kozlowski, which is the New Jersey Supreme Court back in 1979 that held that an oral agreement between 2 unmarried adult partners where the agreement was not based explicitly or inseparably on sexual services is a contract, right? So I think that actually can happen, and obviously New Jersey Supreme Court agreed with us. Too bad they didn't go across the bridge and have this argued. They actually been would have probably had a different outcome. But I think in expressed, it's rather the real question is the terms of said agreement. Can those terms, as long as they don't violate certain things, can those stand in a court of law? But as my argument is going to say, which I guess I'll start now, is this was never an argument of the law. This was always an argument of the facts. And that is the problem here, because when we look at unjust enrichment...
okay, hold on.
It says that.
Hold on. There's a lot in there, and there's a lot of jumping around. So it sounds like you're saying your argument was...
Yeah.
So there were 3 express agreements, right? One was the Dix Hills Home.
Right.
The second one was the joint book venture, and then the third one was Take Care of Life. And so it sounds like the argument you just made is about the taken care of for life.
Well, the argument I'm making is like it depends on the terms and whether the terms stand. But can overview the question, can an expressed or implied agreement, is it a contract? Yeah, as long as it meets the test as well, right? You have to have a bargain for exchange, mutual assent, meeting of the minds, all of that stuff. But yes, then it can hold.
So I don't think there's any disagreement there. I think what we always hear in the law is it depends.
It depends.
So, it depends. I have no argument there. So I'd say it can as well, and we have case law to show that that is the case.
Yes.
But the question is,
what are those terms
at hand?
Yes. Aha. Yeah.
And so as you said, hey, this is
a question of facts.
Right. But it. Okay. So I guess my argument is that this, like, based on the statute of frauds, that her argument just does not stand.
Okay, so now we're getting into those terms, what the terms of that agreement is.
Yes.
So let's start with the first one. So the first one was what exactly?
So the first one was about the Dix Hills area home, and I think we gave some backstory into that. There's a lot of GCT around that with the house burning down.
Just mysteriously set on fire, which is something that 50 Cent would never do. He's crazy. Of course he set that house on fire. Like, come on.
Do you want to give a little bit of the backstory there? We did sort of skip that.
We did sort of skip that. Okay, so this Dix Hills home was purchased in 2006. The funny part is on December 19th, 2006, Mr. Jackson, a.k.a. Kurt, wrote an email saying, and this was in very broken English because y'all know he can't spell. It said, "Neek, it really hurt me to hear you say you think I wouldn't take care of you, ... You can have the house, period. I'll have them put it in your name and I will give you money every month, period. It don't matter to me." That's what he said on December 19th, 2006. They proceeded to purchase this house in a closing a few days later. However, Miss Tompkins asserts that during this closing, Mr. Jackson's attorneys pulled him aside, pulled them in a room and said, "Hey, let's not do this. Let's put it in your name." To which she didn't want to go forward in the closing, but they said, "Hey, don't worry about it. Let's just do it this way and we can put the house in your name later." Which is kind of how this all came about, because this was drawn, this claim was made and the suit was filed and then the house burned down. So now the suit actually says she wants this house that doesn't exist anymore.
Right. And I know she said I was like jumping there, but per the statute of frauds, anything involving real property needs to be in writing.
It's very convenient, isn't it? That the statute of frauds.
She got nothing in writing, so unfortunately.
And my argument is she did get something in writing. She got a whole email in writing saying, "I'll put the house in your name." So I think that's very interesting.
I'd say that was merely a gift. There was nothing bargained for there.
How was it not bargained for when she took care of him, though?
So we're mixing times
but
and events here.
But here's the thing, right? I mean, but the
like
past...
her boyfriend was living in the home. As he said, this was merely a gift to get his son, to have his son in a stable environment. He paid. She did not pay rent. She lived in the home rent free.
I didn't see anywhere in that petition where it says she lived with a boyfriend, by the way. It was there, Jen? It was there. Okay.
Yeah, I think that was subsequent to it burning down.
You said ain't nobody living in my house and burnt it to the ground. I would do that. All I'm saying is, I understand that, yes, the statute of fraud does certainly say that some things are judicially unenforceable if it's not written down. I don't argue with you there. That is a matter of law. Mm-hmm. My simple argument is that this house was a bargain for benefit to Miss Tompkins based on the performance of a duty that had happened previously. And I think it was written down. I think the promise itself was written down because they clearly understood, that mutual assent did happen. Like, hey, I will sign this house. He even says, I'll have them put the house in your name. You can have it. But you know,
So 50
some people
Cent
didn't agree with
actually said
me.
that those statements were made just like love and affection, maybe in
But
the
they
heat
weren't-
of a sexual encounter. This was not.
I think so. The thing that, first of all, if you're writing an email in the middle of sex, then
Well, he doesn't even remember sending the email, so we don't know if someone hacked into the spelling was off. It doesn't seem like
we
it
know
would be
50 Cent
an
can't
email
spell.
sent by
It's fine. He got into a whole argument with Floyd Mayweather about this because he said,
well, it was that Floyd couldn't spell, not that 50.
50 can't spell either. He said, I will pay you $1 million if you read the first chapter of Harry Potter. And I was like, if I was Floyd, I would tell him, I will pay you $2 million if you could read the last chapter. Like, whatever. I don't like this guy. Anyway, he can't spell either. This was sent from his email, unless he wants to prove, which is actually funny you mentioned the email, because in another lawsuit he had against Rick Ross's baby mama, Miss Latasha Levinson, he actually claimed that his email was hacked, and that's how the sex tape got released, which is kind of funny. But whatever happens, I mean, he's saying it's hearsay. He said this, she said that. You know, as a matter of law, the statute of fraud does bar that from happening. The crazy part is, had the house just simply been signed over to her in the beginning of the closing, then there would have been, whether it was a gift or not a gift, right? It wouldn't have mattered. But the other crazy part about that is there was a mortgage on the house, and had the house been in her name, then the mortgage would have also, you know, befallen upon her. And without these monthly allowances that were also promised in this email, how was she going to pay for it anyway?
Right.
So,
I mean, she was getting child support and other.
She is getting child support.
Yeah.
He was paying for trips. I mean, this is kind of getting into your argument here, right? Like, he was paying for things. So, yeah. Yes, I think on the statute of frauds argument over the selling of the house, I think that obviously wins out. I don't agree with it.
Yeah.
I think that she should have.
Yeah. We both have our own opinions, but
yeah,
unfortunately, as a matter of the law.
That's what that definitely came down to. So let's talk about the second one.
Yeah. So I think some practical advice there is get everything in writing.
I tell people all the time, like, if someone promises you, and here's the thing though, the crazy part is, like, not every promise has to be in writing, right? Promises can be orally made. Obviously, like I said, I was quoting some relevant case law. Promises can be orally made even amongst unmarried parties. It's just the statute of fraud bars property.
Yep, property and a couple other
things. Yeah. So it's just on this particular.
That's fair.
It's not fair.
Yeah.
It's not fair.
I mean, what she's saying, it's fair. That's a fair assessment.
So
okay.
Let's talk about this
I think the big thing then is, you know, that contract to take care of the plaintiff for life. So that's sort of the basis of her seeking those remedies, right? I think she said $50 million. Not to be below that.
Not to be something below 50 million. Yeah. And which again, we ran into obviously another statute of fraud issue, right? This is my take on it as the person, you know, representing the plaintiff. Mm-hmm. I would not have argued taking care for the rest of your life. The reason why I would not have argued that is because of the statute of fraud. So he has no way, he's literally incapable of performing this. Because how long is someone gonna live? You can't really take care of someone for the quote rest of their life. The statute of frauds puts limitations on these things on purpose, so you don't end up with lifelong, quote unquote, lifelong contracts. We saw that with the case about lifelong employment, right? You can't really do that. That's against the statute of fraud as well. And a case that I'm working on with my other project that was supposed to be medium is now long, with the Megan Thee Stallion case. You can't have a lifelong record producing, you know, contract. It just doesn't work that way. Right. So I would not have done that. You know, I understand that was the promise that was made. The stronger argument would have been to recoup money that had already been spent on Mr. Jackson in the 11 and a half years through unjust enrichment. And because, you know, she's already spent this money, it's not really looking at it unevenly. It's really more looking at it like, how should my money back? Right. However,
Before you sort of dive a bit into unjust enrichment, and I think we should just define that too, because
let's do that.
It's such a
what does that mean?
think it's a big thing under civil law, and it's like, what does it mean? But I do want to talk about this idea to take care of someone for life, and the thing I think to think about is like, say they were married, and then say they got a divorce, like this idea of like permanent alimony, essentially, which is not actually applicable in most states. And then just thinking of like, even so first of all, if they were married and they got divorced, this idea of like permanent alimony would have been hard to prove. But then say they weren't divorced, and we're just looking at states that recognize common law marriages, and New York is actually not one of those. But just sort of the requirements that would fall under that, or like what legal recourse would she have related to like, a breach of this union, I guess is what you would call it. And even under that, I think some of these claims that she would make just would have no legal
I'm not so sure about that.
Standing. Maybe she would have standing to like some money to get herself back on her feet.
She would have standing if they would have like
him, but this idea that he would take care of her for life, like
if y'all saw the way I'm looking at Jan right now, I'm just staring her down. Like, first of all, let's not. Okay, so if he would have actually performed parts of this contract that she detrimentally relied on, which I'll get to later, like the book, for example, right? Married or unmarried, she would have had legal standing to recoup the cost of that.
So actually, for the book, he was going to upfront her $40K, and then after she wrote the book, she'd get another $40K. So that's $80K. Mind you, this is very different from $500 million.
$500 million.
But I think she got the $40K, and then she never gave a book. So
why would she give a book when he owes $50 million? Like, no, we're not going to do that. And just so you know, in your argument, she did start writing the book. She did not finish writing the book. And actually, he used the manuscript of that book to make a movie, which is called Get Rich or Die Trying. So you can't say...
I highly doubt the whole movie was based on a book that
she wrote. Was there. She knows what was there. I'm saying that she helped write the manuscript.
I can't deny maybe she contributed.
Yeah, she contributed to it. But what I'm saying is, even if... Okay, so let's say that he did upfront her the 40. She finished the book. She got another 40. I think that it would still... We would still be in the process of... understanding that she would have legal standing to still recoup, whether that be because she's depending on the royalties of this book. So basically, there is legal standing. For example,
And this is a little, so we're sort of getting out of the common law marriage thing and just talking about that.
Yes.
Was this oral agreement around the book enforceable?
So we look at contracts like Suggs versus Norris in 1988 and Collins versus Davis, where they're both unmarried, cohabitating individuals, and they enter into agreements for profits. They enter also into agreements for loans and repayments of loans and everything else. And I think, especially in the Collins versus Davis case, when we look at the house, had Ms. Jackson had that house in her name already, and let's say the mortgage was defaulting, as long as she detrimentally relied on him to pay that mortgage, then she would have had a good standing under Collins versus Davis to say, hey, we were cohabitating, or we still are cohabitating. It depends. And hey, I'm relying on this. So I said that to say that in her situation, the way that it has manifested itself, regrettably, she's on the legal downside of it. However, if there were just a couple of things that were changed, namely, if the house was in her name, if the book had been written, things like that I always think of like physical manifestations of a promise, right? Then certainly, right?
Yeah.
It's very difficult. And I think she definitely had an uphill battle proving a lot of these things, even though, in my argument, I think because of promissory estoppel, she detrimentally relied on that, which I'm sure we'll get into.
Yeah, but I'm just going to answer to that, and then we could jump to promissory estoppel and also unjust enrichment. But I'd say that, the burden lies on the plaintiff to prove that there was a binding agreement, and then
Yeah.
define the terms of that agreement so the court knows like what essentially is trying to be enforced. And so there, to ascertain if there's a contract, those terms must be definite. And this idea of take care of, what does that allude to? Is that money? Is that like
I'm gonna pay your light
sexual
bill.
arrangements? Is that food? Like what what is that? And what is the frequency of that? And what does that amount to? And unfortunately, Tompkins could not produce any of that, and so legally, it is unenforceable. And I'd say that those claims lack merit because of that. But
They lack merit, but
let's talk a little bit about promissory estoppel.
Yes, please.
And unjust enrichment. I can kick us off for promissory estoppel.
Go ahead.
And so for promissory estoppel, there essentially are 4 elements. And so first one, there has to be a promise, and just I know earlier you were going to say, well, let's define a contract. And so with a contract, it's a promise plus consideration.
Mm-hmm.
So with promissory estoppel, the one thing is that there's a promise. That promise has to induce reliance. And then 3, someone has to actually rely on that promise. And then the 4th thing is that it has to lead to some injustice, right? So those first 3 are matters of fact for the jury, and then that last one is decided by a judge as a matter of the law or policy. And so I know you brought up promissory estoppel.
Yeah, for sure.
So what are your thoughts on that? Was that used? Did she use that in this case?
She did not use. I think she should have. She didn't. She used unjust enrichment, which kind of ties into promissory estoppel. And the whole thing about promissory estoppel is it's a promise made without consideration, and enforcing that to prevent an injustice. And the key part is if the promisor should have reasonably expected the promisee to rely on the promise, and if the promisee did actually rely on the promise to his or her detriment. I think that she did. So what that basically, how that basically manifested for her was, you know what, you said you were going to do these things, right? I was going to be, quote, taken care of for the rest of my life, which I think the whole point of making a contract in understanding contracts, when we talk about the meaning of the mind, is do you understand the terms of this, right? Because we don't want to go deep into unconscionability or anything, but do you understand the terms of this? Do you understand what you're getting, what I'm giving, vice versa, right? A benefit to one or a detriment to the other. And I think that it was very clear with Curtis and Shaniqua. Hey, you don't have anything. You don't have a house, or as my granny would say, a pot to piss in or a window to throw it out of. And I'm going to take care of you while you try to get your rap career. Obviously he was selling drugs, and that's why he got shot and all this other stuff, right? So I'm going to, quote, take care of you. Well, I, quote, took care of you too. And if you ask Mr. Jackson, well, how did she take care of you? I'm sure he'll be able to list it. She paid the bills, she worked, she took care of our son, this, and this, right?
I questioned some of those, but okay.
You can question it all you want. You know what I mean to take care of your man, okay? So she did these things, excluding sexual things, where that'll blow out my whole argument. So, because you cannot. So
we know there was some sexual things. Because
no, we don't know that.
There was a son.
That we knew that before, but we're not saying she's trying to get paid for that. Because that would blow out my whole relevant case law. So we're not saying that she probably even took that out. That was probably a discount in that $50 million. Okay. So I'm just saying that and even in this case, she did have consideration. But the whole idea of promissory estoppel is.
I would question.
I know you question if it has consideration.
I would say there was no consideration, and using the Witten versus Greeley Shaw, I would say that any promise not supported by consideration is unenforceable. And we know for consideration, it has to be bargained for, and it has to be a detriment to or benefit for, but detriment to the promise.
Yes.
And benefit to the promisee. Oh my
Yes.
gosh, excuse me.
Yes.
I can't talk today.
So, but even with that, like I said, I would just bring up promissory estoppel. I didn't need a consideration to begin with, and it was a detriment. So the thing is, like, yeah, I mean, the thing is, at the end, she reasonably expected this. This is not unreasonable. If people know that if you have a rap career, and if you make it big, you're going to automatically get money, right? You're going to automatically have more money. And I don't think it's unreasonable to think, especially because of the December email back in 2006, that she expected this. So, those are arguments.
Yeah, I do have to say, like, they didn't bring that up, and I think that probably would have maybe been a better.
I don't like the unjust enrichment argument that they used. I understand why they used it, especially especially as it comes into quantum merit, but I would have just combated that with promissory estoppel, and also, like I said, I wouldn't have argued quote for the rest of my life. No matter, even if you did say it, I would probably use it as like a backup or whatever. But
Yeah.
I would honestly just try to recoup the money. But we're gonna get into what the court said and who won this.
Yeah, I think we're almost there. I know one thing I do want to say is like, I know we didn't really talk about unjust enrichment, but I do have to say, like, if you look at Monroe versus Monroe and this idea of like what can be enforced as a contract in a relationship and what is just sort of just the natural occurrence of like love and affection and relationships. And I think that a lot of her claims just fell on what you would expect from two young people in love. I mean, they were teenagers when they met, right?
They were teenagers when they met. I will say to combat that is in Monroe versus Moreau, it said it had to be expressed and not implied, because in that case it was just implied that they would do these things. No, in our case he expressed it.
If you're going back to that email,
the email was there. If they got Hillary on them, then we should be able to get Curtis on it. The emails were there. Also, I don't think that it's completely unreasonable to think that a young couple, especially, I mean, he was shot, he was disabled for I think a year or so before he was even able to get out of that bed.
He had other women helping him. She was not so.
I'm sorry.
He was sleeping with 10 other women. Are they all entitled to a contract with him?
It depends. It very much so depends. And I would very much so like to represent those women who have slept with Curtis Jackson. If you are a woman who has slept with Curtis Jackson, you may be entitled to reimbursement. We're just gonna do one big lawsuit against him for everyone that's ever slept with him. But
I think,
no,
like a mic drop here was Curtis Jackson said, like, if I had even agreed to take care of you for the rest of your life, and I would have married you, and he didn't.
Nobody wants to marry you, Curtis.
So
nobody wants. Also, just this whole idea that you have to marry someone. So that's kind of what the case law says. You have to marry someone, right, to enforce some of these things.
Well, no, we talked about states that have common law marriages.
Right, and New York is not one of them. Should have moved to California.
I think the book is closed there. So yeah, no, I think we've covered.
I think we covered it.
We covered everything. So.
Though I would like to say that no one wants to marry Curtis Jackson, and that I think the relevant case law that I've quoted has proven that unmarried people may, it depends, be entitled to making these contracts, and these contracts are therefore enforceable. So let's get into.
I know she tried to slip that last thing in, but I would say that those are that is not case law in New York. Those are other states.
First of all, relevant case law does not have to necessarily be in New York. Okay, don't be showing off to Professor Jimenez because your case was Monroe versus Moreau in New York.
It was. I do want.
Okay, she got one case in New York. I got 4 cases, I just want to say, and all of them are very valid, and these are the cases that were not just quoted. So I will say this: some of the cases, including Fernandez and Gaza, they were not quoted in the this case. They actually just quoted Suggs versus Norris, but Suggs versus Norris is quoted a lot more cases. Honestly, and I want to just say, like, I think that's a big reflection on her legal strategy that I just don't think was very strong.
Yeah,
like
I would agree with
I
that.
think it was just the way that they aimed it. I mean, honestly, I don't disagree with the statute of frauds. I don't think we should have lifelong contracts, but it's a lot of things, and we talked about this in previous episodes. It's all about legal strategy, how you maneuver, how you move it, and how you think about it. And I think a stronger argument would have been to just drop that whole lifelong promise thing. Stick with what he wrote down, very much so hammer what he wrote down, and then, hey, here's how much my rent was at this point. This is how much, you know what I mean, and average that money out. I don't know if they did that to get to the $50 million. Seems a little steep to me. And also a lot of things when we're suing people is about reasonability, right? We talk about that, especially, like in unjust enrichment, what is reasonable?
Yeah.
And
the chicken case, right?
Yeah, the chicken case, right? So it's about that. So tell us what the court said, Jan.
I think you get the drum roll here.
No, I don't want to talk about it. You get to talk about it because it was your side.
Yes, as we mentioned earlier, this was for summary judgment, and the court ruled in favor of the defendant.
Yes, Curtis
at least
won.
In the breach of contract claims, Curtis won, and this was dismissed. And
they basically said that the statute of frauds holds everything. And then and as far as her unjust enrichment claim, they said that she was not the person who was he was not the person who was unjustly enriched. They actually said that kind of she was.
Yeah. Actually.
It was kind of bad.
That, but,
they basically.
50 Cent brought receipts.
Yeah, so basically just a 10-second wrap up of that was just, hey, he was paying for your grandmama's house, your mama's house, your mama's funeral. Literally, that's what it literally said. We paid for your mama's funeral, your grandmama's furniture. We paid for they brought the Macy's card. Like, that was hurtful. He really just dropped the receipts on her and said, I paid for that Birkin bag. I want it back. Yeah. And also, you want to talk about a house, I'm going to burn it down. And, he just...
Well, there's no evidence that he burned down that house.
Now, Jan.
But we're not going to go there, guys. I know this was about contracts of passion gone bad, and we hope that you've learned some things from this, and you can have
you can get out of a contract by burning your house down. That's what we learned.
Contracts of passion gone well, because, contracts are in every aspect of life, and I
Absolutely.
think this is one where emotions run high. And
especially if your name is Curtis Jackson, and your name is, And we didn't even get into some of the other things that he's done because we were running out of time. But this is definitely a contract of passion gone terribly wrong, especially for that house. And now we're looked into the future, and after the contract was ended, broke all relationship with his son. Yeah. They had to move out of the house. Well, they didn't have a house to move out of because it was burned.
Okay, let's not woes me.
Down and. They had to move back to Queens or Brooklyn. I don't know those boroughs up in New York. And poor Shaniqua. It's already bad enough her name is Shaniqua, which is hard enough to spell. But now she's homeless, and Marquise is homeless.
Oh, okay, guys. Dominique's doing a sob story here. But no, we hope you've enjoyed this tape, this dose of legal tea and things. And as always, join us next week. For a new episode. And
on that episode we'll do 50 Cent versus Rick Ross and how he released a sex tape, and he lost that one. I would like to do that one next week.
Okay. Fair enough. All right, you guys have a great week.
This has been Dominique Alford.
Jan Ingram. Until next time.
See you guys.
Your attention, please. Funny in the club.